Music. Joining us now, Pepper Crutcher, attorney, old friend, Balch Bingham. Morning, Pepper. How are you today, sir?
Good morning. I'm in the promised land of Lafayette County, Mississippi. Couldn't be better.
That's awesome. You going to stick around there for in Oxford for the game? You're going to go over to Starkville?
I am sticking around in Oxford because I've got family flying in from all over, including Southern California, so we're all going to rendezvous here.
Awesome. All right, so wanted to have you on to talk about the status of these vaccine mandates and the OSHA rules. So catch us up a little bit. The president issues this order for the federal workforce, for contractors to the federal government, and then the second part of the rule mandating that employers with more than 100 employees must have all of their employees vaccinated. If they don't, they face fairly stiff fines. But then there's lots of lawsuits that are dropped. This thing, I guess, gets litigated. The Fifth Circuit, I believe, rules that the mandate, a stay, I should say, on the mandate. You can explain to us what that means from a legal perspective. And then there's a lottery, and the Sixth Circuit, I believe, is drawn from the lottery to be the venue for all cases, future cases pertaining to this matter. This is complicated. Where the hell are we now?
We're all over the place. Depending on how you count it, the president and his agencies have issued either 6 or 7 so-called COVID vaccine mandates. It's 6 if you count the federal employee mandate as 1. It's 7 if you count it as 2 because the military part of it is being administered through chain of command.
Gotcha.
There are actually 2 OSHA rules. I call it the double mint rule, two rules in one. There are actually 2 OSHA rules that are in issue right now out of a total of 3 OSHA rules, because you remember that OSHA issued the healthcare facility rule last summer. So
yeah.
2 OSHA rules that are in effect right now are the emergency temporary standard, which was in effect in the Fifth Circuit and joined.
Okay.
But little known, even to lawyers, is that in the same Federal Register publication of November 5th, when OSHA issued that ETS, they also issued it as an Administrative Procedure Act interim final rule, which has to wait 30 days before it goes into effect. So here's what I would do if I were OSHA. I'm now in the Sixth Circuit. I've got a brief to the Sixth Circuit due November 30th. I'd write a brief saying, you know what, we've said we're not going to enforce this emergency temporary standard, and we're not. In fact, we're going to take it down. Case is over. Everything is moved. And then I would do what the administration did with the CDC eviction moratorium. I would, on the December 6th Federal Register page, say the interim final rule is into effect, and maybe with a change here or a change there, but pretty much the same as the ETS. And that would start the whole legal process over again.
Huh. Okay. All right. So, I hear you. It's kind of a novel approach. Not sure what OSHA is going to do about that. But these lawsuits are starting to pile up now, are they not? Given that the OSHA rules have been promulgated, it's 2.5, 3 inches thick document that contains all the rules. The lawsuits are coming out of the woodwork now. Is that true?
Yes. In fact, Saturday, the latest thing of note happened on the Center for Medicaid and Medicare Services rule.
Okay.
And that happened in the Northern District of Florida, where the petitioners had asked for a preliminary injunction barring enforcement of that rule. The court denied it, and for appeal purposes, that works for a final order. So now we'll have an appeal going up to the 11th Circuit Court of Appeals in Atlanta. The OSHA ETS rule is before the 6th Circuit Court of Appeals, which is in Cincinnati, and it got there because of a multi-circuit lottery following the ruling of the Fifth Circuit Court of Appeals in New Orleans.
Okay. All right. So
the things that are not making news right now. Okay.
Yeah. It happens on a Saturday, which seems kind of weird. Please explain to those of us who are legal neophytes what the difference is between an injunction and a stay. Are they the same? Are they synonymous, or is there some legal difference?
There are several categories within those branches of equitable relief. So you can have a temporary stay which is typically given just until the next stage of an argument about something, or you can have an injunction which lasts for the entire remainder of litigation. What the Fifth Circuit issued is an injunction telling OSHA, you may not enforce this emergency temporary standard pending the conclusion of this litigation. And OSHA responded by publishing on its website a notice that it would obey that order and would not enforce the emergency temporary standard pending the conclusion of litigation. The case was then transferred by lottery to the Sixth Circuit Court of Appeals in Cincinnati, where it was consolidated with all other cases of a similar sort.
Okay. All right, gotcha. All right, now I got to ask you this. So Governor DeSantis seems to be kind of taking the lead amongst governors that are Republican governors in particular, that oppose the mandates and have voiced and expressed their concerns about that. He's taking the lead, I believe, by signing a bill into law, if I'm not mistaken, that prohibits a private employer for mandating vaccinations of its employees. First, is that true? Did I get that right? And secondly, do you think that survives a legal test?
Well, that's also my understanding of what has happened. And the reason you would do that if you were a governor opposing any of these mandates is to make as strong as possible your argument for the federalism case. That is, this is a matter traditionally within the powers of the state. The federal government has no plenary police power that enables it to do things like this. We have exercised our authority to the contrary, therefore you should defer to us. That's as strong as you can make the argument, but the general rule is that if Congress has delegated its authority, particularly interstate commerce authority, to regulate in a particular area, that regulation overrides all state legislation, all state rules. So you, being the governor of Florida, could make this argument as strongly as you could possibly make it, and you could still lose. The problem for OSHA is that the Fifth Circuit has said, we don't think the statute gives you this authority. And if you're right, if it does, the statute itself may be unconstitutional as an excess delegation of legislative power by Congress.
So who might then throw a lawsuit, I guess, at the state of Florida? Would it be the Department of Justice, the federal government? Might they sue the state of Florida based on this action by the governor?
Very likely they wouldn't sue Florida. They would just say in their briefs in the pending cases, this has no effect because federal law federal regulations issued pursuant to a law in which Congress is regulating interstate commerce, trump, that is, not to use a pun, override contrary state laws. So it can sit on the books of Florida all it wants, but they can't enforce it.
I see. Interesting. Do you feel like this thing is ultimately going to end up in the Supreme Court of the United States?
Yes. But it wouldn't surprise me if we've got several more rounds to go. So I have lots of friends who are expecting that the Sixth Circuit will rule quickly in early December, and it will go straight from there to the Supreme Court, where we will get a ruling before the January 4th deadline for people to undergo discipline if they don't either mask up and be tested or / get vaccinated. I suspect that what will happen is OSHA will take down the ETS. OSHA will promulgate the rule as a final rule under the Administrative Procedure Act. OSHA will argue to the Sixth Circuit that the ETS cases are all moot for that reason, and the Sixth Circuit might well agree. Courts have a long tradition of not reaching out to decide disputes that they don't have to decide in order to resolve a case. That might work, and OSHA might do it for that reason.
Yeah. Well, when we talked to your partner Lucian a couple of weeks ago about this, he had informed us about this grave danger legal standard, which I think is required, if I'm not mistaken, to enable the president to issue an executive order. We got about a minute left. Is that what the Supreme Court is going to, I guess, factor into its decision?
that's one of the many issues that has been raised and challenges of the OSHA emergency temporary standard. OSHA gets to regulate as an emergency standard outside the Administrative Procedure Act only if they show that there is a grave danger to worker safety that must be addressed before they can complete the lengthy process under the Administrative Procedure Act.
I got you.
Questions have been raised about what is the grave danger. For example, why is there a danger to employees only in large workplaces, not in small workplaces?
Yeah, got you. Pepper, appreciate you coming on, my man. Thanks a lot. We'll talk to you soon. Have a good holiday.
Happy to do it. You too.
We'll be back with more Middays. Stay with us.